So common law systems, instead of relying in legislative statutes to perform decisions, they use legal precedents to decide on legal disputes, giving a kind of flexibility in order to mitigate the harshness of the common law system in the country, plus to fill in the gaps of law that the system failed to address. Equity is a fair and just rule for availing fair judgment to individuals. Equity is viewed essentially as a more modern body of legal doctrine. It serves to complement common law and statute law when there's a conflict between the two of them and neither of them can decide a appropriate verdict. Both laws are in harmony, as the rules already established in common law are adopted and incorporated by the Chancellor into the systems of equity. The law of equity brought about a system where the judges weighed the particulars of the cases to determine their verdict, thus boosting the remedies available to the parties. This will allow to have a more wholesome system of judgment. Common law rules are very formal and rigid, whereas equitable maxims are more amenable to changes. These rigidities of common law can only be addressed by making use of equitable maxims established in order to ensure that the outcome of the cases are really fair. So first of all, we have equitable principles that express that the claimant can get no claimant can get a equitable remedy if he has done something wrong before, or if he has done something wrong that has relation with the claim. So the claimant has to act fairly. Then we have equitable remedies, unlike in common law where the only remedy is damages. So we have 4 types of remedies. The first remedy is injunction, which is an order given by the court to restrain a party from committing a wrong. Then we have specific performance, which is an order given to the defendant to perform the contract he has breached. We also have the rectification, which is an order that requires the defendant to promptly modify the terms used in the document, either erroneous or they don't reflect the real intent of the parties. And finally, we have the rescission, which is a sort of amendment of the contract. It restores parties to a contract to the positions they were before the contract was signed. Furthermore, a legal concept was created by inequity, which is called trust. So trust it's created when a person transfers some property, the settler, to another person, the trustee, in order to beneficiate other person or a group of persons who are the beneficiaries. This concept of trust emerged when the knights had to go on a crusade, and before leaving they gave a friend or a relative their property title in order for this person to take care of it during their absence. Only the title mean that you had the property, so this means that in the absence of the title, the common law wouldn't recognize the right. So equity provided a solution to this, the equitable ownership, that provides that the possibility to go to the chancellor to get some redress, and if everything went well, the chancellor will accept to enforce the obligations undertaken by the trustee to use this. In this way, we can view equity as a mean through which a legal system achieves the balance between the rulemaking process and the need to achieve fair results in individual and separated circumstances. Since precedents are not always a reliable way to rule a case.
When talking about the common law system, we could more easily describe it as a judge-made law that establishes all the civil wrong activities humans should not do. Any law that is created by judges as opposed to being codified in a set of statutes is common law. In common law jurisdictions like the British Commonwealth countries, most civil wrongs were developed under the common law. These ones include assault, conversion, defamation, false arrest, invasion of privacy, negligence, trespass to chattels, and trespass to land. In real life, sometimes we face situations where, although the law is really clear, we have to understand and study each person's situation and background in order to make it fair. All these cases where just applying the law wouldn't be fair are disputed in the courts of chancery, instead that in the common law systems. The Court of Chancery was the court of equity, which developed to provide remedies that are not available in the courts of common law. The most straightforward or easiest example that we're facing a lot in real life to explain the role of equity in these cases is the one of the child custody under a divorce. Applying the law in common law system, the child would have to stay with the mom because that's what the law says. But when taking this case in the Court of Chancery, differently from what happens in common law, the judge will have to analyze both parents' history with the children in order to make the correct decision based on that case. What this means is that the special circumstances of these cases will lead to the decision of the judge. So if imagine the mother abused the child and there was proof of that, then the father would have the total custody of the kid. If both mother and father are having problems with the kid, then the kid would take to another family that can take care of him. When taking these cases to the Court of Chancery, we must keep in mind that all cases are different, so all cases will be analyzed differently depending on the personal history of each case. It doesn't matter what law says in these cases. It depends on each person's situation. One of the fundamental cases of the role of equity in the common law systems is the Earl of Oxford case in Chancery that was in the 1615. So the Earl of Oxford case of 1615 occupies a rather unique position in the development of the English legal system and is frequently referred to as the cornerstone of equity in the modern English legal system. The king once decreed, on the advice of the attorneys general, that if there was a conflict between the common law and equity, the equity would prevail. So what happened in this case was that according to a statute of the Ecclesiastic Lessers Act of 1571, transfers of property by teachers, scholars, or any university deemed to any person for a period other than 21 years will be void. In this specific case, an expulsion action was brought against the defendant, who was Smith. This was currently occupying a property through deeds of transfer that had been written since his first landlord assigned his property, not mindful of statute. The jury held that Smith illegally took possession, so the tenant was entitled to evict Smith. However, a common court order was issued from the Court of Chancery that prohibited the execution of the common law order and granted the quiet enjoyment of the property to its tenants. But this did not mean that the latter annulled the initial law, but rather that it complemented it, since all the common demands against the count were maintained who bought the land knowing that it was illegal. So this was one of the most known cases referring to the role of equity in the common law systems. So to come to an end, what we could say that it's the role of equity in common law systems. So the equity system of law was developed as a measure to address the rigidity of the common law system. Therefore, in its early years, the equity system was largely viewed as being against common law, when actually it's not like this. So, in jurisdictions following the English common law system, equity is the body of law which was developed in the English Court of Chancery and which is now administered concurrently with the common law. Equity is a fair and just rule for availing fair judgment to individuals. As mentioned, equity and common law are not the same things, but one complements the other. Equity serves to complement the common law and statute law when there is a conflict between these two, and neither of them can appropriately solve this conflict.